All right. As more people come in, I want to kind of be on time. I do have a lot to get through today. So I just wanted to welcome you again. This is the Filing for Divorce in Maryland webinar by my law firm. And I guess I will start with introducing myself for those who don't know who I am. So my name is Attorney Cherise Williams. I'm the principal attorney and owner of the law office of Cherise L. Williams. I am a family law attorney and I'm licensed in both Maryland and DC. My offices, we serve Montgomery County, Anne Arundel, Howard, and Charles County. And I'm also barred in DC, so I represent people in Washington, DC. So again, today's session is about how to file for divorce in Maryland. I'm going to go through kind of the steps and also look at the new law that came into place in 2023, because some people are unaware of some of the changes. And so again, if this is your first time, welcome. And hopefully, like I said, you'll learn something. The first thing I want to do before I get into the substance of the webinar is to do a little housekeeping. So this is a webinar and we are recording it. So just keep that in mind. So I am going to have all questions. I'll wait till the very end of the webinar before I'll answer the questions. So there is a chat section that you should be able to access the chat, and you can talk, connect to people and put questions in there. And then I can answer those questions in the end. You may relate to somebody else in the chat. So I leave that open for you. And it's super important that you know, because this is a webinar, I have to emphasize that it is for education and informational purposes only. And it's not legal advice. Since I'm not your attorney, I can't give legal advice. So if you do seek out that legal advice, we're more than happy to have you contact our office for specific information as it pertains to your case. And so my number is located at the bottom, and you'll be able to get that number again at the last slide. Also, this video, because it's being recorded, I will be posting it to my social media, which again, I'll give you that information as well. So please stay to the end so you can ensure that you get that information. So without further ado, I'll get into the substance of why we're here. So, looking at divorce law in Maryland, Maryland since 2023 is no longer a fault-based grounds state. And what that essentially means is prior to 2023, if you filed for divorce and you usually had to have a fault ground, and some of the fault grounds were adultery, cruelty, abandonment. You also had 1 year separation, and so we are now what's considered a no fault state. And the two grounds now that are Maryland law are irreconcilable differences. And what that essentially is when your marriage is beyond repair and you don't need a specific time to say, oh, we've been beyond repair for 6 months or 10 months. It could be one incident that's makes you have irreconcilable differences. And also, only one of you needs to want the divorce. It doesn't take both parties to want the divorce. So this is helpful to some people because you don't have to bring in a lot of evidentiary information. And if some people are in dangerous situations, so it does make it harder when they had the fault grounds. So that's one grounds for divorce under this new law. The other is 6 month separation. And so with 6 month separation, what I previously said, the law before that was 1 year. And so now with 6 months, we're kind of keeping in sync with how DC is, because I know, and because Maryland is so close to DC, sometimes parties will separate and one will live in DC. So sometimes it is easier when the laws in the different jurisdictions close to each other are similar. So 6 months helps people financially and also cuts down on the time that it takes to get your divorce. So, and another big thing is you can actually live under the same roof, and but you have to live separately. So this is something that is super important to understand, and I actually did a webinar on what more detailed last month on what that means. But if you're living separately, you have separate bedrooms, you're no longer intimate with each other, You hold yourself out with some of your finances separately. Now, of course, if you're living under the same roof, you still may have similar bills, but how I kind of like you to look at this as if you're living like roommates. So if you're both contributing, that also can indicate living separately. But again, some people's financial situations don't allow an equal share. So it is a case by case basis. But the main things is the main ways to show that are that you are acting as two independent people and no longer acting as husband and wife. So that's kind of key to when you're thinking about getting divorced and you're preparing to go forward with the required documentation that do I have grounds for divorce? So that's why we started with that. So now we're going to walk through some of the main steps of how to file for divorce once you recognize if you qualify under one of those grounds for divorce. Now, another key thing that I want to emphasize about this webinar, this is going to be based on couples that are separating and want a divorce, but also are actively involved. And what I mean by that is both parties, want they know their whereabouts, you know that the other person is going to actively participate in the divorce. And the reason why I have to put that into this agreement because there are differences if one of those things, if a party's unavailable or there's other aspects, if the party's unknown at this point where they are. So for purposes of that, and this also is going to be based on a contested case. So let's look at that. So first and foremost, you're going to want to file a complaint for absolute divorce. And whether you do that pro se or you do that through an attorney, that is the required pleading. That's the legal term for a complaint for absolute divorce. It's considered a pleading that needs to be filed with the court. And so when you have a complaint for absolute divorce, there's many things that go into a complaint. So I'm not going to get into all of those things, but the grounds for divorce needs to be in there as one of the things, and the forms that you can look for are on there. In Maryland has a website that has e-filing forms, but depending on what jurisdiction you're in, you also can go to the courthouse and get the physical forms. So that's something that would be super important. If you have a lawyer, obviously your lawyer is going to draft up that complaint for you and talk about what goes into it. So where you file generally will be where you live. If you had a marital home, but if you've moved and you've at least lived there and established some form of residency there, perhaps you live there at least 6 weeks and you have a mailing address or you work, you can file in one of those counties in Maryland. So whoever decides to file first may have the ability to get their way as to where the case is actually going to be heard. So just keep that in mind. Um, and with this complaint for divorce, there are required accompanying documents. So one of them is a case information sheet. So the court keeps this document as a way to track who files. And so if you're considered the plaintiff if you file first. So there's going to be a sheet that you need to also have attached or filed with your complaint for absolute divorce. And so the defendant, once you serve your spouse, will also have a case information sheet. And so it just documents kind of who the parties are, if they're represented, what the case, so the court could look at it at a glance and kind of see the issues that you believe are in the case. It doesn't mean that you may discover new issues as you proceed, but it is important to kind of, in your complaint, know what your property issues and your child custody issues are, because the first pleading is what the court is going to believe to start, is what your case is about. So, and it is super important to address those issues. So once you get that filing and the case information sheet, you're going to get a case number assigned to your divorce. So it's important. The case number is going to now give you that procedural case for purposes of that complaint. And those things are going to be put together in a package. The court will then issue called a summons. And so a summons must be served, and it can be served by a sheriff. It's not that it must be served by a sheriff, but that's sometimes easier for people if they're pro se. You will pay someone at the courthouse to serve it for you. You can hire a private process server. It just can't be you. And the person who serves must be over 18 years of age. Okay. So that's super important. And the date, there's going to be a date at the top of the summons. So that's the date the summons was issued to you. So that's super important because you have 60 days from when the date of when that summons was issued to you to serve your spouse. So always keep track of that date and be aware, because if you don't serve within that time, it is possible the court could dismiss your case unless you ask to extend that summons. So that's a whole nother legal filing a motion. And so it can get complicated if you're pro se to know what those documents are. So the best way to avoid having to figure out a bunch of other legal stuff that we learn as lawyers would be to make sure you have it served within those 60 days. And once it's served, they then, oh, yeah, well, I guess you also, another form you have to think about is the financial forms. I'm sorry, because when it comes to service of process, this is what I wanted to say. They have 30 days if they live in the state of Maryland to serve you. If they live in the state of Maryland, they have 30 days. So if they live out of the state of Maryland, then they have 60 days. And depending on after, if they live internationally, the laws and those things can vary greatly. So you don't want to, you have to learn based on the country of origin what those laws would be. So so looking at their response time, you may have a default case if in fact they don't serve you in a timely fashion. And another thing you need to look at is the financial form. So that is a form that is going to kind of talk about the property issues. Now you're going to kind of talk in your complaint of what exists, what you think exists as far as marital and non-marital property. But now this long form kind of lays out your income, your assets value, the debt you have, some of the expenses you have along the way, as well as it's like a spreadsheet essentially of your kind of what you have at the end of the month and what kind of debt you kind of have as well. So the long form is used for when there's support issues, so that means child support. When there are alimony issues, if one party is asking for it, then the long form is required, even if the other party's like, no way, there's no way you can get alimony. That's the form that the court wants to look at when they're making an assessment. So you have to fill that out. And definitely when there's property issues, when there's significant property and business income. So complicated cases require a long form. Short forms are usually only appropriate if there's child support, but typically if the couple makes less than $15,000 a year. So if the couple's between, 15 and really up to 30, they've increased some of these projections, then those cases, the long form is the more appropriate form to fill out. So now that you know those things, I also wanted to talk about, before we move to the next part of this, is when you file in Maryland, you can file in person, which if you go to the courthouse, there's a clerk's office, you can file your documents in person. But now all of the Maryland courts are electronic systems. So what that means is there's an e-filing system. So if you decide that you are capable of like scanning documents and you want to learn it, there is a website that allows you to e-file. And so you can go on the Maryland courts website and look for that. But once you register to do that, you can't then decide to go into the court and file in person. So if you do decide to do that, which makes it a lot easier to file, you do have to have a credit card. It'll tell you the rules, but that's an option, and a lot of the lawyers are required to e-file, but as a pro se litigant, you also can register to do that as well. So just keep that in mind. So now we're going to move on to what comes next. I've gotten an affidavit of service from whoever files. So that 18-year-old that you get to file, or 18 or over, they need to file what's called affidavit of service or fill it out. Then you can file it, which is basically an indication of the description of where they serve the person, what they look like, just to make sure that it is either the person or someone who's willing to accept service on their behalf. So if they live with someone, that may suffice. And that person acknowledges that they're willing to take it on behalf of the person because they know the person. So that is something that needs to be filed. The court will then do what's called a scheduling hearing. And so the scheduling hearing is the first hearing where you're going to appear. And it sets the tone of the case because if you're the plaintiff, you're the one who has to bring the case forward on your complaint for absolute divorce. And so this is a contested case, so the way that I'm doing this presentation today. So the court believes the case is still contested. And so they're going to schedule further dates. Now, since you have a contested procedural case in the courts, they're going to set further deadlines in the case. So in any contested divorce case, there are still going to be opportunities to settle. So one of the things the court is going to ask for parties if they're appropriate for mediation. And mediation is a conflict resolution option that allows for a third party to sit down with you and talk to you and your spouse about if you can settle the case. So they'll schedule that out. If there's domestic violence or an inability for the parties to talk in that way, then some cases get conflicted out of mediation. So there is a case by case basis, but majority of cases are scheduled for mediation. There's also, if you have kids, something called a parenting seminar. And this is to co-parent. Just because you're a parent, you may be a great parent, but co-parenting divorce can be very different for a lot of people. And so they try to set a foundation through these seminars so that you can start to think a little differently now that you're no longer going to be married. So this co-parenting seminar is going to be scheduled, and then there's different classes, but you're going to be required to do that, and then you have to turn in a certificate to show that you did that. So that's super important. Then they'll schedule discovery, which is an exchange of information between the parties. I won't get too deep into that because it's super complicated, but typical discovery includes interrogatories, which are questions to be answered, and production of documents, which are documents to be produced. So as a plaintiff, you generally want to serve on the other party interrogatories and production of documents. And those that will allow you to get information about their case and what they plan to say in defense of whatever your claims are. And then they can serve them on you. So the court will issue a scheduling order giving you a timeline for when you have to serve those things and by when they have to answer those things. So that's important for you as a pro se person to understand the deadlines and meet those deadlines because there's consequences if you don't, and it can cost you, it can exclude witnesses in the future. So understanding and doing research on interrogatories, production of documents. There's also something called request for admissions and a deposition. Those are generally higher level, and if you have a lawyer, they'll understand all of those things. But the basic ones that everyone will do, I say 90% of the time, are interrogatories and production of documents. So that's super important for you to understand. And then there'll be a settlement conference with a retired judge that's also scheduled. And that's another opportunity to settle. So let's say you go to mediation, you're unsuccessful because you go to mediation with no documents. You just go there to talk, and nothing in mediation should be used against you in the court case. But you may not be successful that early on settling. Now, post settlement conference, which is typically scheduled after you've finished discovery and it's in the court, involving the court, even though that there's a retired judge, you've typically exchanged discovery of some sort. So now you have a clearer financial picture of what each party has, because generally you'll have to submit what's called a pretrial statement, which lists out potential witnesses, the issues you still believe are present, which could be custody, it could be marital versus non-marital property. Like you have to identify what is marital and what's non-marital. And so those are big things. There's something also called a joint statement concerning marital property. So on that, you actually identify in writing what each person claims is marital property, is not marital property, along with their values. So that could be their fair market value. Let's say it's your marital home. you may have had an appraisal, you may not have, but if you have, you could use that price. If you haven't, some people, go on some of these websites and may have something that they believe to be a number. Your spouse may have a different number, so that's just something you can put on there that you are willing to say, as of right now, so when I'm filling this out, this is what I believe the value of this house is. These documents are super important. They can be modified in the future, but you are signing them under oath. So you should be putting what you really truly believe in. And so if there's debt, credit cards, bank accounts, all of that needs to go on that form so that everyone is clear about what is the court would be deciding in the future. So that's part of the what is needed for the settlement conference. As well as if you have children, there's something called a parenting plan, which is also there's a form that you can complete ahead of time, and it lays out the custody schedule. So custody involves two aspects: physical, where the child will physically be, so you can lay out the schedule that you're proposing, and also the legal aspect, which is decision making. And so that is, generally speaking, joint is the preferred option in Maryland. So if you're deviating from that preferred option, you have to kind of articulate why. And so essentially that form has different boxes you can check and lines you can fill out to say what you agree on and what you disagree on. So that is something that the settlement conference judge will be able to look at ahead of time, and kind of when you're in that settlement conference, they can help narrow down issues, identify issues. Here you just tell your side of the story, but because there's no requirement to settle, but they do try to make an effort to try to resolve the issues that they can. So that is something that you need to kind of go in with a plan and be prepared to talk. So that's something that's scheduled at that initial scheduling conference. So yes, if you get to the settlement conference and you're still not in a position to talk, say, let's say documents still haven't been turned over, you just can't settle, the retired judge doesn't have much authority there. So you'll move on to what's considered the next procedural stage, and we'll get to what that is. After the settlement conference, there's something called a pretrial conference. And so this is where the actual judge that will hear your case will be. And if you have a lawyer, the lawyers and yourself will appear. And again, you have this pretrial statement that has to be presented to the judge with your witnesses, exhibits, not the physical exhibits, the list of exhibits, the amount of time you believe the trial will be, because it may have changed from when you first started. So there is opportunity sometime to request more time, but the courts now are getting more strict about that. So, and then also if there's outstanding discovery or motions that have been filed along the way, that can be talked about and resolved at this discovery at this pretrial conference. So it is a formal procedure where you're going over what to expect at trial and to see again if anything can be resolved before trial. So that's another opportunity. That one, you not generally, there's not a settlement at that one, but at any point when the parties get together, if there's a way to settle the case, the court's never going to turn that down. So just keep that in mind. Um, and so after the pretrial conference is concluded, so I've had cases where pretrial conference, there's one and they schedule another one, just if there really is a complex case. So that's always possible. But generally, the next thing that happens is the trial, or and if at any point along the way you do settle the case, what that looks like and what that means is you will have what's called a marriage separation agreement. And usually that's in writing. Usually you will write the terms out as a contract. And if you have that at trial, you won't have a contested trial. You'll have an uncontested trial. So it won't be a long hearing. If you are able to settle it and far enough before trial, then your case may convert to the uncontested divorce track, and your hearing will be for a 10-minute hearing, and it won't even be a contested trial on the dates that you have scheduled for trial. So that's a possibility. But let's just say that doesn't happen. You go to trial, there's no settlement. Now we're at the divorce trial. So this is where the judge has to make a decision on custody, property, whether they're alimony, you can ask for attorney's fees if there's attorneys involved. So this is where the plaintiff has to present their case, and you need to know what the law is, what the standard is. The courts are getting away from being lenient for pro se people. The expectation is you've done your research and you understand what you have to prove, because you can lose out on some of your rights if you're not well informed. So that's part of why it is sometimes very important to have an attorney, but people don't always do that. So obviously it's up to you to understand what each part of a divorce looks like under Maryland law and how to prove those parts of your divorce. And also, after your case is put on, the your spouse will then have the opportunity to put on their case as well, and the witnesses to be called. You need to have your witnesses available, and you need to prep them. You need to make sure you know what they're going to say and how much time it's going to take, because as a lawyer, there's a lot of time it sometimes can take to question people, and the way that people talk, fast, slow, and then cross-examination. You can't always predict how long the other side is going to cross them. So these are all the trial prep things that are important in a case, and bringing your documents, having multiple copies, things like that. So looking at it from that point of view is important. And after the trial, the court will gather all the evidence, and it's not likely going to happen the same day, but they'll come up with a judgment. And so that will be the judgment that at the time that the court decides based on the evidence presented. And if the judgment for divorce will usually come out of that. So that's generally speaking the process that you go through for a divorce in Maryland. And there's a lot of intricacies with each of these steps and documents and forms. A lot of them are on the Maryland website, but if you don't understand them, you know, you can ask for some help at the court, but it's preferred to get a lawyer. So some of my tips that I have for people who are going through a divorce that I think is important for you to think about when you're preparing for these things. It's super important to stay organized with all of your forms and the things that you need for your divorce. That's number one. It's also important for you to make extra copies of documents. So you want to stay organized, make extra copies, because if you have exhibits, you're expected to share them with the other side, share them with the court, and things like that. If there are deadlines in that scheduling order, you need to follow those deadlines. There are consequences. They need to hold the other side accountable for following the deadlines. And when you go through a divorce, you have to go through a lot of documents and information. So you want to go back, you have to subpoena documents or go get your own records. That's your responsibility to do that. If they ask for your bank statements, your credit report, text messages, your social media account, there is a way to download this stuff. There is a way to preserve these things for court. So that's all part of the process. And so if you have a lawyer, they're going to help manage your litigation. They are going to help discuss settlement. They're going to advocate for you, and they're going to tell you, hopefully, the truth. Sometimes clients ask for things that are not possible. You try to do your best to serve them and be realistic. But there are laws, so no lawyer can guarantee you an outcome. But we've seen a lot of things, so we can kind of give you tips and ideas of what we've seen before. So it's important that you know that, so that and you're helping your lawyer, you're working with your lawyer, and you're being honest, because if a lawyer can't defend you if you're withholding information. So now we're going to move on quickly to some questions. Because that is yeah, some questions. And again, one of the questions that came in, so I appreciate this question, is if their property is divided and it's in it's not there, one of the parties' name's not on the property, essentially. Like, let's just say it's a house and there's a mortgage and deed, and the other person's name's not on either. What happens to that property? How is it divided? So one, in order to make a determination of marital property, your name does not have to be on the property. The analysis is basically how was that property acquired? Like when, not how. So if it was acquired during the marriage, there's an assumption that it's marital property. So your name doesn't have to be on it for you to have an interest in that property. That's super important to know, because a lot of people don't have their name on property for one reason or another. but they still can have claims to it. Retirement is marital asset, and that's usually in the person who's working's name. So if there's property bought, that's marital home, and if there's property bought, that's property used for having extra income, it still can be considered marital property. If it's not inheritance or a gift, it's generally going to be marital property. It's up to the person claiming that it's not marital property to prove that it is marital property. I mean, that it's not marital property. Sorry, they have the burden of proof to show the court that it's not marital property. So that's definitely something that you need to prepare to do with evidence, documents, receipts, and of how you acquired that property. And just because it's your job, because your income, that's marital property. Bank accounts, marital property, even if it's in your name alone. So debt as well. So you get the good and the bad. So your debt is the other person's debt. So these are things that people, that's why don't always understand and need to understand when they're getting divorced, so that you have a big picture of what you're doing when you're splitting up assets, because the court has to make an equitable decision. Equitable doesn't always mean equal. If one person's doing things with their money like gambling, and the money is not coming into the marital home, or doing something like that, or an affair where they're spending money outside of the home, the court may say, well, then this person is not going to get a 50-50 share of this equitable distribution because they've been wasting money throughout the marriage. So there are facts and things that can alter how the property is divided. So always keep that in mind if you're raising these things in a divorce. So I think that's the only question that I have time for. I'm going to look in the chat one more time. Okay, it doesn't look like there's any others. So looking at this page, these are my social media handles. I will be posting this to Facebook. And so if you didn't see the whole thing, you certainly can rewind, not rewind, but go and check it out over there. 50 Shades of Law is my handle on most of my social medias. There's only an underscore on Instagram. So please, if you want to follow me, you can do that. But if you also want more personal advice or need an attorney, my number is 240-499-8569. So call us to schedule a consultation. And I do webinars usually monthly, and so if you like this webinar, please join us anytime on these webinars. We love to give out information, and I love doing what I do. I like helping people. I know these are difficult times that you're going through. You're here for a reason, and I wish you well on whatever you decide to do, and you're welcome for thanking me. I appreciate that. So I want to say have a wonderful night, and I will see you next time.